Association here on Ashmore Street, Monrovia. As you may be aware, a couple of days ago, the bar informed the Liberian people through an official press release that it was gearing up to provide its response to the Supreme Court's ruling in the amended Bill of Information filed by Councillor Honorable Fonati Kofa. Today, we are happy to invite you, and we are glad that you have all gathered here today, where the President of the Liberian National Bar Association, matter of fact, the National President of the LNBA, Councillor Olovama, will be providing to the Liberian people through the media the position of the LNBA as it relates to that ruling from the Supreme Court relative to the amended Bill of Information. Mr. President, the President will read the position of the bar. It's lengthy, but it's very exhaustive of the key issues, and we'll take 3 questions following that. Okay. We will take a couple of questions, a few questions, if we have the time. And we are happy that you're here, ladies and gentlemen of the press. The President, the floor is yours.
Thank you, Anthony Sefeni. Members of the media, there's a press statement of media release today, April 28, 2025. The Liberian National Bar Association responds to Supreme Court ruling on Speaker Kofa's Bill of Information, amended Bill of Information. The Liberian National Bar Association, LNBA, acknowledges the Supreme Court of Liberia's recent ruling on the amended Bill of Information filed by Speaker J. Fonati Kofa. While the LNBA notes the April 23, 2025 Court's opinion as a testament to the Court's role in interpreting constitutional matters, the Bar respectfully disagrees with several key elements of the ruling. The office of the Bill of Information. While the LNBA upholds the authority of the Supreme Court as the final arbiter of constitutional and legal questions, we are constrained to express our disagreement with the Court's interpretation and its practical implications on the doctrine of separation of powers. The LNBA affirms that a Bill of Information as a procedural tool is designed to clarify the implementation of a judgment or bring to the Court's attention issues affecting its mandate. It is not and should not become a substitute mechanism for settling inherently political questions, particularly those relating to the internal organization, leadership, or operational independence of the legislature. The ongoing conflict within the House of Representatives is a matter that, though it may involve constitutional questions, is primarily political in nature. It requires political resolution through institutional dialogue, consensus building, and adherence to democratic norms. While the Court may offer interpretative guidance on legal issues, the enforcement and implementation of its opinion in such matters depend heavily on political goodwill and respect for constitutional boundaries. The LNBA is concerned that repeated reliance on the judiciary to resolve legislative disputes may erode public confidence in the independence of both branches of government and may set a troubling precedent while political actors abdicate their responsibility to resolve internal conflicts. Under Liberian jurisprudence and practice, a Bill of Information is intended to clarify or enforce a judgment where there is confusion or obstruction. While the Court's decision to allow the Bill of Information was justified and procedurally correct, given the confusion surrounding the meaning and application of its prior ruling of December 6, 2024, the LNBA observes that the Supreme Court expanded the function of the Office of Bill of Information by reasserting and elaborating its prior ruling, effectively issuing a new substantive decision rather than simply clarifying it. This expansion risks inflating the Office of Bill of Information into a de facto remedial tool, inviting future parties to misuse it for re-litigation rather than seeking clarification from the Supreme Court. The LNBA asserts that on December 6, 2024, the Supreme Court ruled by indicating the following: wherefore, in view of the foregoing, any sitting or action by members of the legislature not in conformity with the intent of Article 33 and 49 of the 1986 Constitution are ultra-virus. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the parties, and it is hereby so ordered. Distinguished members of the media, Rule 4, Part 12 of the revised rules of the Supreme Court of Liberia prescribe the Office of Bill of Information as follows. A bill of information will lie to prevent a judge or any judicial officer who attempt to execute the mandate of the Supreme Court in an improper manner from doing so with the judge and or mandate of the Supreme Court. B, a bill of information will also lie to prevent anyone whomsoever from interfering with the judgment and or mandate of the Supreme Court. From the above rule, it is over declared that a bill of information in this jurisdiction, in its legal context and application, is a proceeding that complains of a judge or judicial officer who attempts to execute the mandate of the Supreme Court in an improper manner, or any person who interferes with the mandate of the Supreme Court. In other words, a bill of information may be brought against a judge, judicial officer, or any person whomsoever who acts contrary to the mandate of the Supreme Court by disobeying, interfering, or obstructing the mandate of the Honorable Supreme Court. The bar states that the December 6, 2024 ruling of the Supreme Court did not have any clear mandate to which a bill of information could lie. However, the bar agrees with the Supreme Court on the clear purpose of clarification of the December 6, 2024 ruling. The bar believes, therefore, that the Supreme Court erred by allowing informants in the proceeding to use the Office of Bill of Information to have the Supreme Court issue a second opinion and a judgment in the same constitutionality case, which is very different from the first opinion in the same case. The decision of the court to declare any sittings or actions of the majority bloc respondents to the exclusive presiding officer of the House of Representatives while he is present and available to preside is unconstitutional without the appeal of the law. That is in the wisdom of the Supreme Court. In its April 23, 2025 opinion and judgment, the Supreme Court said that any sittings or actions of the majority bloc respondents to the exclusion of Speaker J. Fonati Kofa, the duly qualified presiding officer of the House of Representatives, while he is present and available to preside, is unconstitutional and without the appeal of the law. The LNBA emphatically states that if the sittings of the majority bloc are illegal, obviously then the 2025 national budget is illegal, and all persons who participated in the process and or have benefited from the process are guilty of having participated in an illegal process and facilitated the consummation of its illegality. The LNBA believes that the Supreme Court has indicted itself of committing a very serious offense under the circumstances. That is why it is important that the Supreme Court quickly reconsiders its opinion and judgment and expunge itself from this embarrassment. Moreover, the Supreme Court's opinion and judgment constitute judicial overreach into matters exclusively reserved by the Constitution to the House of Representatives, and this violates the separation of powers doctrine, the cornerstone of a Republican form of government. The LNBA shall not condone legislative overreach in matters reserved by the 1986 Constitution to the judiciary. Similarly, the LNBA shall not act or observe judicial overreach in matters reserved by the Constitution exclusively for the legislature, the House of Representatives Speaker, and how the Speaker may be removed from office for cause. This is simply a violation of political question doctrine. Under Liberian law, the political question doctrine is a principle rooted in constitutional interpretation that holds certain issues that are more appropriately addressed by the political branches of government, that is, the executive and legislature, rather than the judiciary. This doctrine is derived from the doctrine of separation of powers, which is enshrined in Article 2 and 3 of the 1986 Constitution of the Republic of Liberia. key features of a political question doctrine under Liberian law. 1. Judicial restraint. Liberian courts, particularly the Supreme Court, have held that where a matter is inherently political, involving policy decisions or the discretion of the executive or legislature, the judiciary will refrain from intervening. 2. Supreme Court jurisprudence. While Liberian jurisprudence does not have an exhaustive list of political questions, the Supreme Court has applied the doctrine in cases involving impeachment proceedings, legislative internal affairs, matters related to foreign relations or national defense, the conduct of election, though courts have jurisdiction in cases of alleged violations of election law or constitutional backing. Article 2 gives the Supreme Court the power of judicial review, but limits it where constitutional interpretation gives discretion solely to the political right for a system of checks and balances under which the court must respect the domains of other branches. Of course, this has limitation. The doctrine does not shield political actors from judicial review when there is a clear violation of constitutional rights, due process, or other various actions. The court can review whether a political decision followed the procedure required by law, even if the substance of the decision is political. That is why the LNBA notes the opinion of the Supreme Court that Councillor J. Kofa remains the legitimate Speaker of the House of Representatives on ground that his removal was unconstitutional, consistent with Article 49 of the 1986 Constitution, which states the House of Representatives shall elect once every 6 years a Speaker, who shall be the presiding officer of that body, a Deputy Speaker, and such other officers as shall ensure the proper functioning of the House. The Speaker, the Deputy Speaker, and other officers so elected may be removed from office for cause by resolution of a two-thirds majority of the members of the House. The LNBA therefore calls on the Supreme Court incident, which will erode confidence in the governance of Liberia, to remain standing. Finally, the LNBA notes that should the Supreme Court fail to record and reverse itself, thereby making the 2025 budget illegal, disbursements of salaries and payments made by the executive of goods and services will be illegal, and this will disrupt government operations and undermine the credibility of the state. Some might liken this to criminal subversion of the government. The LNBA, as a critical institution responsible for the guidance of the state, calls on the Supreme Court to quickly move to avoid any calamity in Liberia, the impact of which will affect the stability of the country. This call is against the background of preserving public policy interest. LNBA position on quorum consistent with Article 33. The Supreme Court's interpretation of Article 33 and 49 of the 1986 Constitution raises significant concerns. The designation of the Speaker as the sole presiding officer, even in the absence of a quorum, appears to overload procedural flexibility necessary for legislative operations. The silence of the Constitution, House rules, and statutes on compelling attendance to session further complicates the practical application of this ruling. The LNBA comes in straight defense of Article 33 of the 1986 Constitution. The representatives shall elect once every 6 years of a Speaker, who shall be the presiding officer of that body, a Deputy Speaker, and such other officers as such ensure the proper functioning of the House. The Speaker, the Deputy Speaker, and other officers so elected may be removed from office for cause by resolution of a two-thirds majority of the members of the House. This defense, therefore, advances the idea that for any sitting of a legislation that has a quorum to be considered unconstitutional, the Speaker, Deputy Speaker, or any other ranking officer must be absent, or in other words, not present and available. Presence and availability in this instance does not merely denote being within the physical confines of the designated area, but also properly seated among similar colleagues and ready to exercise one's constitutional functions. The LNBA, under such circumstances, is constrained to disagree with the Supreme Court that Speaker J. Kofa was present and available for legislative business. LNBA emphasizes that the interpretation of Article 33 and 49 must align with the principle of democratic governance and the separation of powers. While constitutional order, it inadvertently creates challenges for legislative functionality and accountability. For example, holding that there is a speaker, any session held without him as presiding is legal will present a case of absurdity. What if a quorum exists, he's present on the premises of the capital, but chooses to ignore? The LNBA thinks that ignoring a quorum will undermine legislative business. Recommendations. We urge all stakeholders, including the legislature and the executive, to engage in constructive dialogue to address these concerns. The LNBA remains committed to fostering the culture of respect for the rule of law, while advocating for interpretations that promote institutional harmony and democratic progress. As a legal community, we stand ready to provide guidance and support in navigating these complex constitutional issues. The LNBA reaffirms its dedication to upholding justice, protecting constitutional rights, and ensuring the stability of Liberia's democratic institutions. Meanwhile, the LNBA proffered the following recommendation. The LNBA calls for the establishment of an independent mediation committee to resolve the impasse in the House of Representatives. The committee should comprise of eminent Liberians, for example, former chief justices, the LNBA leadership, inter-religious council, and civil society actors, in line with the Supreme Court's opinion, where it states that the opinion of the Supreme Court might not be sufficient to resolve the impasse in the House of Representatives. The mandate of the rival factions and recommend a unified leadership framework for peaceful resolutions. Thank you.
Thank you very much for the time.
President of the LNBA.
Okay. So that's it for now. We are very grateful for you being here and getting the official position of the Liberian